Who can brief us a little bit on how we got to this point.
Starting in October, the Plan Commission was asked by the City Council to consider regulation of nude dancing. Nude dancing in terms of liquor establishment is regulated by the states, and that's under the 21st Amendment, so there's really no problem with regulating a licensed establishment. But then the question arose about establishments that don't serve liquor. And in those cases, nude dancing is considered expression. It's protected by the First Amendment, so there's no way you can ban it. You can't regulate it in terms of reasonableness. Well, it takes a considerable amount of crafting, which is what we've been doing with regard to what we've come up with today. Now, I'm informed that not a whole lot of people came in to take a look at the proposed ordinance, which we've been sort of tweaking the last few months. So I was asked to just briefly explain what's going on. When we first started considering this, we had a public hearing that was more heavily attended than tonight's one, and a lot of the objections to nude dancing came about morals, about religion, about kids being exposed to it. And what was difficult to explain to people was that this is protected speech, and what we have to do is not something that's motivated by morals or religious beliefs or whatever. We have to do this in a reasonable manner because it is protected speech. And the key word, the buzzword, as they say in law school, is prior restraint. What we have to do is create something that doesn't place a prior restraint on the expression of free speech. To that end, in addition to consulting with me, our City Administrator Bill Marx has also engaged Bill Thiel from the Wald Riley firm, who's an expert in municipal law and has dealt with this issue in the past. And he is as responsible as I am in this proposed ordinance and how it's come down to this with consulting with the Plan Commission, which is going to make a recommendation one way or another this afternoon, unless, of course, problems arise that they feel fit to send it back to the drawing board. So what originally started out was creating a place for this rather than downtown. And once there was, usually these ordinances are predicated on findings available from materials that really argue both ways with regard to secondary effects, which is that oftentimes these establishments are crimes precipitated or occasioned by the establishment of nude dancing places. We did look at studies. There were studies that came to the opposite conclusion proposed. However, we had our ordinance contains what we believe is two striking examples that's close to home here. One was the Cumberland Island Bar in Cumberland, which ended up getting busted for prostitution back in the 90s, and in the early part of the new century, there was the Jack of Diamonds in Trigo, that Trigo place, which was busted for maintaining a meth house. And those are examples that are available on the web. Those are cited, those are actually published cases, both in federal court and in state court, and are available to those to look at, and those quotations or the citations for that are in here. So the question became, should we make this a conditional use or a permitted use? Bill Thiel had felt that putting conditional uses is dangerous. In other words, hours, distances from schools, things like that. We did look at, Larry Stelter had shown us an example of a conditional use that exists in the city of Superior, but when I called up the city attorney there, he said that was so constructed as to outright ban it. The setbacks, the other restrictions that were imposed on nude dancing were such that there was no logical place that they would fit in the city of Superior. And he admitted that they were in danger if somebody else decided to come in. They do have 2 establishments there that are what the common term is called grandfathered in. And those are uses that have been in existence before zoning came in, before zoning dealt with this problem. And so if they're in continuous business, they can always continue to exist because the owners and their successors have a vested interest in it. So after looking at that, we decided to make a permitted use, and that's why we're proposing today to create an adult entertainment district and set aside property that is owned by the city so it's available for whoever, but doesn't tie up any private property, so that people can object to, well, my land's inside this district and now it's prejudiced by this. This is sort of off by its lonesome and is available, if this ordinance passes, would be available for use as an adult entertainment district. Although that isn't going to be part of a published ordinance, if this ordinance gets passed, that would be our first available place. If that's taken up, we do have to find another place for adult entertainment. Adult entertainment is then defined. We've narrowed this down. We considered like a broad definition, including adult bookstores and so forth. Again, Bill Thiel decided that, or advised us that we take it out. For instance, in paragraph 5, businesses that features a regular and substantial portion of its business, live entertainment, blah, blah, blah. He said take out substantial because that's going to be a problem for you. So that's basically what it is. It would be a permitted use. Otherwise, our ordinances, in terms of setback, building structure, would just go along with it as any other business or residents in the city. And so that's what we have before you tonight.
All right, thank you. Want to add anything at this point?
I want to add one thing, that if this does pass and a business were interested in the land, our liquor ordinance still would not allow that establishment to have both adult entertainment and liquor.